Welcome all to the channel Scientellectual. The topic of the current video is penalties under Chapter 20 of Indian Patents Act 1970. The relevant sections are Section 118 to 124. Penalties. Section 118 to 124 of Indian Patents Act 1970 deals with penalties and offences related to Indian patent system, and these penalties are in the form of either fine or imprisonment or both. Section 118. On the ground of contravention of secrecy provisions relating to certain inventions, if any person fails to comply with the direction as given under Section 35 or makes or causes to be made an application for the grant of patent in contravention of Section 39, that is, if any person goes against the direction that is given under Section 35 or Section 39, he shall be punishable with imprisonment, which will be extended up to 2 years, or may be punishable with fine, or maybe with both. Now, Section 35 deals with secrecy directions relating to inventions relevant for defense purposes, and Section 39 deals with the residents not to apply for patents outside India without prior permission. Section 119. On the grounds of falsification of entries in register, that is, for somehow there is false information entered in the register. If any person makes or causes to be made a false entry in any register kept under this Act, or a writing falsely purporting to be a copy of an entry in such a register, or produces or tenders or causes to produce or tender evidence any such writing, knowing the entry or writing to be false, then he will be punishable with imprisonment, which can be extended up to 2 years, or may be punishable with fine, or maybe with both. Section 120. The ground is unauthorized claim of patent rights. When a person falsely represents that any article sold by him is patented in India, or it is the subject of an application for a patent in India but actually it is not, then he will be punishable with fine, which may be extended to 1 lakh rupees. Now, for the purpose of this Act, a person shall be considered to represent that an article is patented in India. It should be stamped, engraved, or impressed on, or otherwise applied to, that is, patent application is submitted, not yet granted. The article, the word patent or patented, some other word expressing or implying that a patent of the article has been obtained in India, it is not right. It should be properly patented. Only a word that it is patented or it is a patent is not sufficient. Article that is the subject of an application for patent in India, if there are stamped, engraved, or impressed on, or otherwise applied to, the article, the words patent applied for, or patent pending, or some other words implying that application for patent has been made in India, that is also not sufficient. So, it should be properly patented. Then only a person can claim that he has patent. Otherwise, the word patent or word patented or the word patent applied for is not sufficient to claim that he has a patent. The use of the words patent or patented or patent applied for, patent pending, etc., expressing or implying that the article is patented or application has been made, shall be deemed, that is, shall be considered to refer the patent in force in India or to be a pending application in Indian Patent Office, as the case may be, unless there is an accompanying indication that patent has been obtained or applied for in any country outside India. Section 121. The ground is wrongful use of words Patent Office. If any person uses on his place of business or any document issued by him or otherwise the word Patent Office or any other words which would reasonably lead to the belief that someone would believe that his place of business or he is officially connected to the Patent Office, then he will be punishable. And the punishment can be imprisonment, which may be extended to 6 months, or maybe fine, or maybe both. Section 122. The ground is refusal or failure to supply information. If any person refuses or fails to furnish to the central government any information that he is required to furnish under subsection 5 of section 100, or to the controller any information or statement which is required to furnish under section 146, then he will be punishable with fine which may be extended to 10 lakh rupees. In section 100, subsection 5, there is an explanation of extent of use of invention, and central government may ask the applicant to furnish some documents. If he fails to do so, then he will be punishable. Under section 46, there is a statement regarding working of patent invention on commercial scale in India. One should file Form 27 under Rule 131 of Sub-Rule 1 and Section 146, where he should furnish about the working of his patented invention on commercial scale in India. If he fails to do so, even after controller asks him, then he will be punishable. Section 122, subsection 2. On the ground of refusal or failure to supply information, if any person being required to furnish any information as referred in subsection 1, if he furnishes false information or statement and which he either knows or has reason to believe to be false and does not believe to be true, then he will be punishable with imprisonment which can be extended to 6 months or maybe with fine or maybe with both. Section 123. The ground is practice by non-registered patent agent. If any person contravenes the provision of Section 129, where Section 129 defines the restrictions on practice as patent agent, then he will be punishable with fine which may be extended to 1 lakh rupees in case of first offence and 5 lakh rupees in case of second or subsequent offence. Section 124. The ground is offences by companies. Subsection 1. If the person committing an offence is a company, the company as well as every person in charge of and responsible to the company for the conduct of its business at the time of the offence shall be deemed to be guilty of offence and shall be liable to be proceeded against and also will be punished accordingly. Now, nothing will render any person liable to punishment if he proves that the offence was committed without his knowledge and or he exercised all due diligence to prevent the commission of such offence. Now, penalty is, it will be charged accordingly as it occurs in case of individuals as per provisions mentioned earlier. Section 124, subsection 2. Regarding the offence by companies, notwithstanding anything which is mentioned in subsection 1, where the offence has been committed by a company, and it is proved that the offense has been committed with the consent of, or that the commission of the offense is due to the negligency due to director, manager, secretary, other officer of the company, then that director, manager, secretary or officer will be punished and he will be considered as guilty of the offense and punished accordingly. Now, company means any body corporate and includes a firm and other association of individuals. And director in relation to a firm means partner in the firm. Thank you viewers for watching the video. Please give a like and please share and subscribe the channel Scientellectual. Keeping in mind the upcoming patent agent exam, we are providing all the necessary informations regarding Indian Patents Act 1970. Thank you all.